Okay, we are live now. So, bom dia a todos. Bom dia, boa tarde, boa noite. Não sei de onde você está assistindo, nem a que horas você talvez vai assistir. Eu sou a professora Ângela Kretschmann, advogada. Advogada e professora. We have some problem here in sound. Bom dia a todos. Bom dia, boa tarde, boa noite. Não sei de onde você está assistindo, nem a que horas você talvez vai assistir. Eu sou a professora Ângela Kretschmann. Bom, então, retomando que eu vi um eco no som, então eu tive que parar aqui e fechar uma janela. Eu estou aqui com o professor Thomas Hoeren, a professora Cinthia e o professor Yogesh e vou apresentá-los a vocês, mas antes eu gostaria de dizer a todos que estamos abrindo este painel que trata sobre the New International Data Economy, one analysis of the impacts in the European Union, India and Brazil. Eu vou intercalar um pouco o inglês e o português, né, se vocês me permitirem, para auxiliar na compreensão de todos, pois essa mesa ela será conduzida nas duas línguas, não simultaneamente. Então, nós vamos intercalar um pouquinho. Eu vou passar algumas informações rápidas sobre o funcionamento do painel. As apresentações serão feitas em inglês e português, primeiro as em inglês e depois em português, e todos serão primeiramente apresentados, né? Para obter o certificado de participação, você só precisa se inscrever no evento do CODAIP, preencher todos os dados, e eles serão emitidos após o evento. Então, poderão ser acessados online, esses certificados. Em nome do GEDAI e da Universidade Federal do Paraná e da comissão organizadora do evento, eu gostaria de dar as boas-vindas aos nossos palestrantes de hoje e a todos vocês, ouvintes. Hi everyone, I am Ângela Kretschmann, lawyer and researcher at Federal University of Curitiba, and I'm here to introduce you the panel, the New International Data Economy, Analysis of the Impacts in the European Union, India and Brazil. First, I will give you some tips on how the panel works. Our presentations will be held in English and Portuguese, and we will open at the end of the speeches for questions. Then, we will dedicate the remaining time to conducting debates and answering any questions from the audience. So, to whom have questions, we ask to write in the chat, and if possible in English, because it will facilitate our debate and will save time and misinterpretations. To get the certificate, just register at CODAIP event, filling in all the data. Certificates will be issued after the event and will be accessible online. Now, with great pleasure, I will introduce you our speakers. First, Professor Thomas Hoeren, our first speaker, is one of the legal advisors of the European Commission at the Legal Advisory Board on Information Technology. He is also a board member of the Research Center for Information Law of the University of St. Gallen, Switzerland. Since June 2000, he's working as a domain name panelist for WIPO, and in 2005, he became a member of the expert committee for copyright and publishing law at the German Union for intellectual property protection. Since 1997, Professor Hoeren is based at the Institute on Information, Telecommunications and Media Law at Westphalian University in Münster, Germany. And he has been a Superior Court judge, and over the last 20 years, he has been involved in research on intellectual property law and computer law. Since 1997, he is director of the Institute for Information, Telecommunications and Media Law, ITM. And he told several times he's not a fan of traditional view of IP law. He created the Institute for Information Society, where intellectual property is only a part of it. He's also a great and very committed and recognized photographer. Then we will have Professor Yogesh Pai, from India. Dr. Yogesh is a specialist in intellectual property, IP law, and has cross-cutting research interests at the interface of IP with competition, trade, and economic policy. Dr. Pei is co-director of the Center for Innovation, Intellectual Property, and Competition at National Law University Delhi. He is also responsible for IPR chair at NLU Delhi, established by the Department for the Promotion of Industry and Internal Trade, Ministry of Trade and Industry, Government of India. He is on the World Trade Organization's advisory list for regional trade policy courses and a tutor for WIPO Academy Distance Learning Program. He will talk about non-personal data protection in India. And Professor Dr. Cinthia Obladen de Almendra, Freitas. She is graduated in civil engineering from UFPR, master in electrical engineering and industrial informatics from UFPR, and PhD in informatics from PUC-PR. Full professor and coordinator of the graduate program, master's and doctorate in law at PUC, judicial expert in several courts, technical assistant for several law firms, consultant member of Innovation and Management Commission of OAB. She will talk about the LGPD and its application in Brazil, results of LGPD panel in the courts. We are very happy and grateful to have you here with us, Professor Thomas, Professor Cinthia, Professor Yogesh, and we feel very lucky having this opportunity to be mediating this debate. On behalf of GDAE and the event organization, I'd like to say thanks to our speakers. Thank you very much. Now I call Professor Thomas Hoeren to talk about the new European Data Act and its impact on the international data economy. Please, Professor Thomas Hoeren, you can start.
Oh, thank you very much. I'm proud to be here again as a third time, and I'd like to be here. Unfortunately, I cannot speak Portuguese, but I have my slides made in Portuguese. And I will start with a very nice picture. The Buridan Bo is a nice story of legal philosophy. In the Middle Ages, there was a donkey, and he had to die because he could not decide which bottle of water he can drink. There were 2 bottles of water, and they were too full. So he could not decide. He said, yes, this one, and then he died. That's for me a very important symbol for European policy as to data. So I have planned to show you 5 observations what happens. First observation. We have so many European regulations in the moment that nobody understands what is going on. It's called a data strategy in the European Union. And it was based on a document made in 2020. So don't talk too much about the documents. I will skip to show you what happened after the development of the strategy. We have various regulations like the European Data Act, and very important. I will talk on certain features. Then we have the European Data Governance Act. Then we have a competition law regulation called European Data Markets Act. Then we have another regulation. You see, it's very complicated even for Europeans to understand what is going on in this moment. It's done every month is a new proposal. So we have a European Data Services Act. Then, of course, we have the GDPR in Europe, the General Data Protection Regulation, responsible for data protection. Then we have a special act on ships, ship protection. And the last ones is the an Artificial Intelligence Act. It's still in discussion in Parliament. And recently, only several days ago, we had a new plan for AI liability directive. So you see a lot of regulations and regulation. Second observation. All these regulations are totally complicated and are based on an unclear concept of what is artificial intelligence. I will explain that to you. I start with Article 3 of the proposal for an Artificial Intelligence Act. It says, what is artificial intelligence is software developed or using one or more of the techniques and concepts listed in Annex 1. What is Annex 1? Annex 1 has a long list. What is included in the definition? It includes machine learning concepts, logic and knowledge-based concepts, statistical approaches, logic programming, knowledge bases, a lot of things. Is extremely wide. So the differences between conventional software and artificial intelligence is almost impossible to make. And when you take the artificial AI regulation, you will see is regulated horizontal. So every area of the economy in Europe which applies AI, whatever that is regulated. And they invented a system of very risky technologies, medium risky technologies, weak risky technologies, and no risk technologies. And the distinction between all these different regulations is very difficult. The same applies for the Data Act. What is data? Data includes any digital representations of acts, facts, or information. That's almost everything. And that includes the other term mentioned in the Data Act, products. The product is every product which integrates data. So very broad. Third observation. What we now have in Europe is a total mixture of public law and private law. And to tell you the truth, I am a private law professor, and I like to fight for civil rights, for the private rights of people. I am not a public law professor, but what is happening in Europe is a total mixture of public law models and private law models. I will explain you that in a second. And I will use the Data Act to demonstrate what happens. We have discussed now for 30 years whether we can define a thing called property of information, so a data property. Every researcher was publishing an article whether we can have a data property integrated in civil law. Nobody was the winner. So there was no chance to find a very good and sophisticated model for that. In the Data Act, we have a different model. That is, somebody who is the data owner whatever the data owner is, has to give the rights to a data user. And on request of a data user, he has to give the data to third persons. Imagine you are buying a Volkswagen, of course, the best and famous trademark in the car industry. So you buy a Volkswagen car. Volkswagen owns, of course, is the inhaber of data. So they can use the data in a car only with the permission of the data user. And he has to close a contract, Volkswagen, with all the persons who want to use the data. So if Volkswagen, for instance, stores the pressure of cars, pressure of gasoline, they need to give that data to the holder of the car or on request to third parties. That's, of course, very dangerous for Volkswagen because a third party might, for instance, be a car repair service, a free car repair service. So Volkswagen is obliged to give the rights away on request of the car holders to the car repair industry. That's totally new, and we never had that. It's a model which is only used in competition law. That the competition law gives the right against powerful societies to use the rights for the car holder or for a repair service. So let me see. So the data, so the products should be designated in such a way that data generated by users' use of the product is accessible to the user, and the data controller is obliged to make the generated data available to the user immediately, free of charge, in real time. So we have a new model. We have a data controller, not a real data owner, because we don't know what a data owner is, and data user. So and I will show you that slide. I think this model taken from competition law involves the idea that fundamental rights, which are normally only rights given by constitutional law to the state or powerful organization, is now extended to every enterprise storing data in a car, in an electronic device, in a refrigerator, and so on. That's very dangerous. Fourth observation, still today, most people think it's only enough in Europe to install a person called Data Privacy Commissioner, to have a policy in the area of privacy. But that will change dramatically because due to all these new regulations coming up in Europe, we have the model of data policy. We need to have a data commissioner in a company, not taking care mainly for the privacy issues, but for the commercial rights of data. But this idea is getting restricted only to Europe, because the European Commission is afraid of having a free exchange of data throughout the world. They hate the United States, and therefore they say we want to have a free exchange of data in Europe, but not for American companies. I will show you that. The Data Act integrates a lot of rules on cloud, cloud storage. And you see, we have made several decisions and saying that a cloud system in a computer, which is based on the big players like Microsoft or Apple, is held inferior, that is held bad, very bad. And so I mentioned one case of a court in Germany, where it's decided that it was totally forbidden to transfer data to the United States. And therefore, you cannot ask Apple or Microsoft to get a job for the state. In the Data Act, you find the same mistrust towards non-European organizations in the rules of Article 27, saying that an international transfer of data can only be made if all the contracts change. So some mandatory requirements for cloud contracts are also one part of these regulations. Now I'm coming to my main observation. There's the 5 rules, and there's a typical observation done by a German law professor. Of course, to have so many regulations, so against the international free trade in data economy, refers to a situation that the law professor needs to be involved in the discussion. So we need a critical study, a critical review of academia, so that overlaps can be avoided. One example for that. I need example 2. If you take the Data Act only applies to non-personal data. It's the first regulation we have on non-personal data. So that really leads to really severe problems, because the relationship between the GDPR, the General Protection Rules and data protection, and the Data Act are totally unclear. If you give away data because you think you are part of the Data Act, and you are not allowed to do that under the GDPR, you are sued by having to pay high fines. If you restrict your data according to the GDPR, but you have to open it under the Data Act, again, you're fined under the Data Act. One example for that, if you have for Volkswagen has a so-called VIN number. It shows the machine number, the car number in the machine itself. If you make the mistake to think that is a non-personal data, so, and you think you are part of the Data Act, you are fined under the GDPR. So it's very, very complicated, even for such a big law company like Volkswagen, to know which data in a car are non-personal and which are personal. That's almost impossible to make it. And that leads to a lot of problems. the only solution for the problem can we find if you take Big Bang Theory. You know Big Bang Theory in Brazil? Yeah. There you see the famous guys from Big Bang Theory. You see Sheldon and you see Amy. So that's Sheldon and that's Amy. And in volume 10, they made a suggestion how to solve the donkey problem. They said, what we need is a donkey which takes time to decide the matter. So the donkey would never need to die. He just have to relax and think and consider, and then he can drink one bottle and then the next bottle. So that leads to my last remarks. We need to be quiet. Lawyers are only legasthenics of progress. So quiet, consider all the overlaps and disambiguities and so on. If you think I need help, you can get my slides. I hope I have not made too many mistakes in Brazil in the Portuguese language. You can even have podcasts, ebooks, if you are capable of reading German. And you can see all the information on my website, and you can send me an email. I will try to answer every language, every question you have. So I say, obrigado por sua atenção. Thank you very much.
Thank you, Professor Thomas Hoeren. Your Portuguese is great, impeccable. Yeah, well, I'm really curious about how we can compare these so many regulations and how we can survive to all of it. And I will ask now to Professor Yogesh, and we don't lose more time. And after all, we will start with Professor Cinthia, and then we go to the questions, okay? So Professor Yogesh, welcome.
Thank you, Professor. Thank you, Professor Ângela Kretschmann. It's really an honor to be on this panel again, meeting after 1 year, I think. I think this is also my third time, as Professor Thomas just mentioned. It is also a third time for him. Thank you very much for the invitation. And the topic for today's discussion that I have in mind is the non-personal data governance framework in India. What is being the current practice and what is its future? So just to go back and try and take a look at what we want to discuss in relation to non-personal data, definitely this does not involve any questions of privacy. The focus of my presentation, and unfortunately I don't have a PPT, nor can I speak Portuguese, so I'll go with English, and the only two words I know in Portuguese are hola and obrigado. So hola to all of you, and you know, I will go on with the lecture in a very slow fashion so that everybody is able to understand, even if they're using a translator. So we are not discussing about privacy issues. We are not discussing about personal data protection. But just to give you a background about personal data protection in India, the government had introduced the bill in 2019, but there were several controversies associated with the bill, and it did not pass into a law. And the government withdrew it just a couple of months back, and they are proposing a new framework for personal data governance. But what I want to speak today is about non-personal data governance in India. And non-personal data governance assumes significance in light of a committee that was formed by the government of India in 2020 to look into the issue of how to require data sharing. And the main core of my presentation today, or the lecture today, is going to discuss this question of data sharing from the perspective of competitiveness, which means data sharing in between competitors and data sharing vis-a-vis competitors and downstream users of the data. Now, if you go back to our discussion and try and see, go back to the topic and try and see what is non-personal data, it is all kinds of data, particularly raw and unstructured data, that is not part of any kind of personal data regime, right? So personal data, which is anonymized, also becomes a non-personal data. And what is the kind of data are we talking about? The kind of data we are talking about is in terms of recent advances in data collecting techniques, wherein in the age of artificial intelligence and IoT, what is increasingly becoming possible is that wide range of data can be mined through sensors, through other applications, and this data is generally machine-generated data, and then this data becomes valuable, particularly in the AI context, because large chunks of data can be analyzed, and data analytic techniques within AI can be used. And that's the reason data has increasingly gained prominence. And in relation to big data, we are talking about products that involves a lot of raw data collection being possible, particularly in cars, in planes. For example, you have planes, wherein you have some 50,000 sensors or more, which collect terabytes of data. And that is the kind of raw data we are talking about. But these raw data has certain economic characteristics. First of all, this raw data is non-rivalrous in the sense that this data can be used in parallel. That's why the society tends to benefit from the use of the data if there are multiple users of the same data. But unfortunately, in the creation of the data, there needs to be an incentive for someone to collect this data in the first place, even before we talk about the parallel uses of the data due to its non-rivalrous nature. It is also important to understand that this data at some level, competitors cannot know the quality of this data in advance, primarily because this data is in the exclusive possession of firms. This data is highly private, in the sense that car companies collect them and keep them safe, and they use both legal and technological methods to keep the data in private. Legal in the form of copyright law, very minimally, but contract law and trade secret law, wherein breach of confidence actions are brought against people who steal data, is quite possible. And technologically, you use cryptographic methods and technical protection measures and anti-hacking measures against the use of such data. And because of this kind of a de facto exclusivity that is there with the firms who collect the data, data largely today is transacted within the firms without that data getting disclosed. But the problem for public policy has largely been that this data is useful for competitors and also for downstream users who would want to make or build products based on that data. So what is the current legal framework in India for this? The current legal framework primarily is through a structural layer of technology and hacking and data theft measures provided by the cybersecurity laws in India, primarily the Information Technology Act 2000, wherein sections 43 and 66 provides for civil and criminal remedies, along with other provisions of the Indian Penal Code, wherein data theft can be penalized. The other development in this area is also that the Government of India in April 2002, under the IT Act, issued a report on cybersecurity, and they said that if there is any cybersecurity breach in relation to any data, it must be reported to a particular agency, and data leak and data breach can be then handled through the information technology law. The second kind of structure that we have is a measure that is protected through contract law. So if data which is in the de facto exclusivity of the firm while being transacted through contract law, if there are contractual violations of that data being disclosed, etc., then definitely the contract law of India would come into play, and that largely helps private companies to transact and monetize data and gain value. The third layer is a very minimalistic layer provided by copyright law, because copyright law does not provide any kind of protection for raw data in India. Copyright law in India only protects original databases, which are original for their sequence, structure, and organization. We don't have a system for protection of non-original databases in India. And hence, the question of protecting raw data that we are talking about, which is the topic of the discussion, cannot be largely protected through copyright law, primarily because it's not a valid subject matter to be protected. And the fourth way in which, and this is one of the major ways in which data protection, non-personal data protection happens in India, is through the common law remedy. Now, the common law remedy of what is called as breach of confidence is based on principles of unfair competition, wherein any kind of misappropriation of undisclosed information, you have a similar remedy, wherein even if there is no contract in between the parties, but still, by virtue of standing in between the parties, if a party has breached confidence, then such breaches can be sanctioned under the law by providing injunctions and damages. To some extent, in India, the common law remedy, which is the judge-made law, has started evolving and has now started also protecting data, what you call misappropriation, against third parties, wherein if the third party has been reckless in its behavior or is grossly negligent to know that it is accessing data that has been obtained through a breach of confidence, then a third party could also be injuncted from the use of data by virtue of the extension of the breach of confidence remedy to third parties. So these are primarily the way that the current law has developed and protects data against any kind of misappropriation breaches. However, what has also happened in the recent years is that because of the pressure and particularly Indian companies wanting to access big data sets and valuable data sets to make valuable downstream products and even competitive products, there has been a demand for data sharing requirements. Now, this has not reflected in any legislation as yet, but the government of India formed a committee called, led by former, former corporate honcho, who is now has his own data company. And this committee was tasked, led by him, this committee was tasked to, look into this very question of how to regulate data. And they came out with certain, kind of very upsetting conclusions for a lot of people, particularly big data industries. One of the things in the first report they mentioned was that all data needs to be shared on fair, reasonable, and non-discriminatory terms. But when there were 1,500 submissions made on the first draft of the report, then they took back those, those recommendations, and they now don't, talk about sharing data on fair terms, but what they talk about is actually a requirement to share raw data, and they make a distinction between raw data and other kinds of proprietary data. Now, this kind of a distinction, as in my opinion, is highly artificial, primarily because, according to the committee, only inferred data is basically data which raw data which you have analyzed, and inferences have been drawn based on that, and only that data is proprietary, and the raw data, etc., is not proprietary. This distinction, according to me, is artificial, primarily because principles of unfair competition through the trade secret law and breach of confidence extends currently to any kind of data that is held in the exclusive possession of the firm, provided that the data is not otherwise available in public domain. Even if the data is collected from the public, in the sense that it is non-personal data collected from public spaces, yet the data is essentially held as part of confidential information, primarily because it is not available in the same configuration in the public domain. In the public domain, there is always a potential for any competitor to go and collect the same data from the same source. But having said that, it's the moment the data is collected by one private company, it holds de facto exclusivity to the data, and the principles of unfair competition will extend to such data. Now, in the revised report of this committee that wanted to look into the question of regulating this data, they have not looked into this question of how in practice and in the real world data is held by companies. And in some of the meetings after the report was released, committee members expressed views saying that data is like the infrastructure, it's like the roads, it's like the it's the infrastructure for the modern digital network, and hence even if principles of confidential information extend to them, such principles must be overridden through regulation. And that's where we are with reference to the question of regulation. However, the question of regulation primarily is a competition question. And if it is a competition question, we also need to look into the current competition law framework in India, which is the Competition Act 2002. And whether under the current competition law, unless there is an abuse of dominance with reference to the data not being licensed, would there be any form of abuse attached to refusal to license data, etc., are not very clear to us. And this interplay between the competition authorities and the proposed regulatory authorities would be very interesting to watch in the days to come. So what is my conclusion in this regard? My conclusion is that although India has not taken any strong measures with reference to enacting a new data producers' right, unlike, for example, the European Union, which miserably tried and failed, that is the data producers' right, they had proposed during the directive, and that did not happen. Similar attempts have not at all been made in India, which is a good thing. Why? Because the status quo is actually good law that provides large, at least this is my preliminary opinion, because I am also conducting a project on this particular issue. And my preliminary opinion is that the current structure with reference to data protection, non-personal data protection in India through technology law, through that is IT law, through contract law, through copyright law, minimalistic layer, and also through breach of confidence is sufficient enough, and we don't need to provide a positive property rights form of protection in raw data. So what then is the future? The future looks to me like, I think the status quo with reference to non-personal data is going to prevail unless there are too many overriding reasons that the government of India and the parliament would be convinced of that there is a very strong market failure in terms of data licensing. And for that to happen, the private industry, particularly the Indian industry, which tends to benefit from any data sharing requirements being imposed through a regulation, would have to show a very high degree of burden. They will have to discharge a very high degree of burden of instances where this kind of data has is of such a nature that it is a kind of an essential facility, and because of that it requires to be shared on certain fair and reasonable terms. However, I don't know if that is likely to happen, primarily because the big data industry in India also has a lot of clout with reference to its own business models, and this clash between the big data companies and the users of the big data who want to develop new products is going to be the next round of huge perhaps constitutional litigation in India, because at the end of the day, although property is not a fundamental right in India, it's still a constitutionally protected legal right, and any kind of interference with such a legal right to property would be questionable. But having said that, primarily because data is not property and because we have not enacted a positive property legislation like the one proposed in the EU, for example, the data producers' right, these constitutional questions still remain quite open. So I'll end my discussion here and will be happy to take any kind of questions. Thank you very much.
Thank you very much, Professor Yogesh Pai. It's really interesting to compare these so different realities and these differences. What I ask myself is how it will be possible in the near future to separate personal data from what is non-personal data, as we have the powerful of data mining, you know, working with non-personal data that can give our personal data to the public. This is something very interesting, but we will talk about this later. And now I will call Professor Cinthia Freitas. Please come and speak with us. Now we can listen to you in Portuguese. I hope Professor Thomas, he knows some words, and Professor Yogesh, I think we will learn something also, because Professor Cinthia speaks very slow. And then we meet all together at the end with the questions of the audience. Thank you. Please, Professor Cinthia.
Thank you, Ângela. I'm very glad to participate in this discussion and learn more from Professor Thomas and Professor Yogesh. I would like to thank you and Professor Marcos about the invitation. And I will do my presentation in Portuguese because we have a lot of details and names that's better to pronunciate and explain in Portuguese for the audience. So let's start. Thank you. Ok. Bom dia a todos e todas. Então, eu venho apresentar um pouco sobre o que a gente, de uma pesquisa realizada, da qual eu pude participar, e que ficou denominada Painel LGPD, que é a nossa legislação brasileira, de Brazilian Personal Data Protection Act, e que nos permite, então, fazer um primeiro retrato da aplicação da nossa legislação. A agenda que nós vamos seguir é uma apresentação inicial do projeto de pesquisa, de como isso foi operacionalizado, alguns procedimentos metodológicos, alguns resultados, né? E algumas reflexões aí sobre o futuro da LGPD a partir desse retrato do próprio painel. Para quem tiver interesse para conhecer o painel LGPD, pode consultar esse site que está nesse link que está no slide e vai ter acesso aí a todas as decisões que foram trabalhadas e analisadas durante um ano de pesquisa. Então, o projeto ele nasceu como uma proposta e uma parceria entre o Centro de Direito, Internet e Sociedade, o CEDIS-IDP, do Instituto Brasileiro de Ensino, Desenvolvimento e Pesquisa, e o JUS Brasil. Foram abertas inscrições para a seleção de estudantes e pesquisadores voluntários. Eu fiz a inscrição, né, passei nesse processo de seleção para, então, participar desse projeto. Houveram reuniões, estudos, leituras, né, e a parte de pesquisa empírica, especificamente, tudo isso aí se desenvolvendo no prazo praticamente de um ano e pouco, com a publicação do resultado no painel. Então, o objetivo desse trabalho era compreender e mapear as principais tendências dos tribunais, do STF, do STJ e do TST, dos tribunais regionais federais, dos tribunais regionais do trabalho, dos tribunais de justiça e dos tribunais regionais eleitorais também, quando da aplicação da LGPD na fundamentação de sentenças. Então, precisava-se, após, né, a vigência da LGPD, em agosto de 2020, termos aí, durante o ano de 2021, esse levantamento desse primeiro ano, digamos assim, de vigência da nossa legislação. Os coordenadores do projeto, a doutora Laura Schertel, o professor Dr. Danilo Doneda, professor Dr. Braulio Guzmão, né, os líderes de projeto, doutora Bianca e doutora Isabela, os líderes de pesquisa, efetivamente, que orientaram e trabalharam próximo, né, à parte da pesquisa empírica, e depois um conjunto de pesquisadores voluntários, aí em torno de 50 pessoas, que passaram por esse processo de seleção e participaram, então, dos estudos durante esse 1 ano de trabalho. Em relação aos procedimentos metodológicos, foi feita uma filtragem de assuntos no banco de decisões da JUS Brasil, lançando mão aí dessas 4 palavras-chave, digamos assim: LGPD, Lei Geral de Proteção de Dados Pessoais, Lei Geral de Proteção de Dados e a lei com a sua numeração, né, 13.709. O retorno dessa busca encontrou 584 decisões publicadas entre setembro de 2020 e agosto de 2021. Então, foi esse 1 ano aí, né, de vigência da LGPD. Então, essas 584 decisões foram analisadas qualitativamente pelos pesquisadores, houve uma divisão, né, entre os pesquisadores de que tribunais cada uma das pessoas iria trabalhar, né, e das 584, então, resultaram 274 que efetivamente aplicavam, né, ou tinham no seu bojo essas palavras, ou seja, a referência à Lei Geral de Proteção de Dados. A gente vai analisar um pouquinho, né, quais as relações aí um pouco dessa indicação e como isso estava dentro dessas decisões, se fossem de primeira instância ou não, né? Então, a maior parte das decisões, 62 delas, trata do capítulo 1 da LGPD, disposições preliminares, ou seja, menção aos fundamentos, aos conceitos, né, que a legislação traz em relação a dados pessoais, dados biométricos, tratamento de dados, operador, controlador e assim por diante, e também em relação aos princípios. O segundo capítulo, mais recorrente, é o capítulo 2, que fala, então, dos requisitos para o tratamento de dados pessoais, sendo, então, aí discussões um pouco mais genéricas quanto aos aspectos processuais relativos principalmente à produção de provas e discussões sobre as bases legais, destacando-se aí o consentimento, né, que vem como um elemento bastante importante na LGPD e que também se demonstrou aí já nesse primeiro ano de aplicação da legislação como um elemento de destaque. Essa evolução, né, mês a mês, dessas decisões, então, a gente observa essa ondulação, né, ao longo do tempo, mas uma certa tendência de crescimento, né, em que a gente consegue observar aí, ao longo do tempo, a evolução. Isso também é possível olharmos por tribunais, né? Então, o maior tribunal com referência à LGPD é o Tribunal de Justiça de São Paulo, depois o TRT2, Tribunal de Justiça do Paraná, TRT4, Tribunal de Justiça de Minas e assim sucessivamente, né? Então, se formos olhar por segmento da justiça, a gente observa que 47% é justiça estadual, 41% justiça trabalhista, 8% tribunais superiores e depois justiça federal e justiça eleitoral. Em relação ao número de decisões, né, que foram localizadas nesses tribunais todos que eu comentei no início, a gente tem, então, essa distribuição aí em quantidade, uma análise quantitativa, só para fazer um comparativo, né, e até mesmo, obviamente, relacionado ao tamanho, né, se compararmos aí Tribunal de Justiça de São Paulo com outros estados, obviamente, o número de ingressos de ações e de processos numa quantidade muito maior também. Quando damos uma olhada, então, dentro da própria LGPD, ou seja, relacionamos o que está nas decisões, né, como uso para o embasamento, temos aí, né, 49% com o capítulo 1, decisões preliminares, como a gente já comentou, o capítulo 2, quase 5%, e depois, sucessivamente, os demais capítulos da nossa legislação, observando aí, né, essa diminuição de referências, então, a partes da LGPD em específico. Aqui só para demonstrar quantitativamente, né? Então, 35 decisões em relação a dispositivos preliminares, 34 do capítulo 2, direito dos titulares já se destacando, né? Ou seja, já sendo tratado, mencionado, né? Com uma quantidade de decisões, depois do tratamento específico de dados pessoais em relação a dados sensíveis, né? E depois a questão da segurança e do sigilo de dados, ou seja, da segurança e as boas práticas, que traz aí talvez algumas questões de operacionalização e que relacionam proteção de dados e segurança da informação e mecanismos, né, tecnológicos para que se possa efetivamente operacionalizar, e também questões normativas, como a ISO 27000, né, a família de normas ISO 27000, ou modelos aí de boa prática, ITIL e COBIT, que estão também relacionados com essas questões. É possível ter o acesso no site de todas as decisões na íntegra, então, para quem quiser estudar cada uma delas, analisar, né, pode fazer isso diretamente, isso já está público, né? Além disso, é possível classificar as decisões, e isso foi um trabalho que os pesquisadores, nós pesquisadores voluntários fizemos, né? Que o tipo da decisão ela foi categorizada em uma decisão regular, uma decisão didática, uma decisão polêmica e uma decisão inovadora, né? Principalmente aí a questão didática, trazendo fundamento, explicando, relacionando com outras legislações, né, como o Marco Civil da Internet e o Código de Defesa do Consumidor, questões polêmicas que estavam sendo tratadas em paralelo na mídia e também decisões inovadoras que traziam a LGPD já como uma proposta de novo olhar, de um avanço em relação àquela questão que estava ali sendo discutida. E a temática, né, que foi relacionada em muito relevante ou relevante, né, para fazer uma diferença em relação também a essas questões que fossem mais polêmicas ou inovadoras também. Então, alguns resultados desse painel, né? As decisões se referem a diversas áreas e tratam de temas muito variados, né? Indo muito além das discussões sobre danos morais, porque muitas vezes isso foi bastante discutido, né? E falado que talvez a LGPD acabasse num conjunto só de pedidos, né, de danos morais, e isso, na verdade, a gente observou que não é somente isso. Há decisões relevantes que limitam o tratamento de dados pelo poder público, né? Algumas questões aí que estavam e foram tratadas e discutidas, inclusive, pela mídia no Brasil, que aplicam também a LGPD a investigações criminais, e, portanto, há discussão, né, no Brasil de uma LGPD penal, né? Bem como aí determinam a cessação do tratamento de dados realizados sem base legal. Então, a preocupação aí, né, com o consentimento, com a justificativa de finalidade, de tempo de tratamento, né? E as decisões, então, elas foram sistematizadas em 6 temas principais: tratamento de dados na investigação criminal, publicidade de dados pessoais em reclamações trabalhistas, coleta de dados para uso como prova em ação judicial, compartilhamento e acesso à base de dados do poder público, fraude nas relações de consumo decorrentes do uso indevido de dados e danos morais decorrentes de vazamento ou uso indevido de dados pessoais. Então, observem que essa é uma ordem não por importância, mas que também está relacionado com as temáticas que foram encontradas, né? Em relação aos fundamentos das decisões, chamou a atenção o quê? Que muitas citam a LGPD, mas, como eu comentei, não fazem uma fundamentação aprofundada. Porém, acabam fazendo uma relação entre a LGPD, o Código de Defesa do Consumidor e o Marco Civil da Internet, que lá, já em 2014, já tratava, né, de algumas questões em relação a dados e uso de dados, né? Então, qual seria o futuro da LGPD, né? Não temos resposta, estamos andando, né, com a legislação, vendo as coisas acontecerem, mas os resultados que foram apurados, né, considerando aí esse primeiro ano, mostram o quê? Que é possível e é necessário, né, o amadurecimento da jurisprudência, e que isso virá com o tempo, ou seja, à medida que a legislação for sendo melhor entendida, for sendo melhor aplicada, que as empresas e o setor público vão entendendo as devidas adequações que precisam fazer, né, para estar em conformidade com a legislação, isso vai acontecendo num andar, digamos assim, gradativo. Diversas sentenças proferidas em primeira instância ainda guardam decisões em instâncias superiores, então não é possível a gente ter um retrato, né, completo daquele entendimento, e os resultados preliminares demonstram que os tribunais ainda não se posicionaram a respeito de temas importantes e não é possível identificar uma orientação jurisprudencial consolidada, apenas alguns indícios de tendências que estão sendo construídos, estão sendo elaborados, né, para que se possa ter aí um entendimento, como eu falei, tanto dos usuários, das empresas, do setor público, dos titulares de dados, dos agentes de tratamento, né, e também, obviamente, do Poder Judiciário. Então, acho que com isso eu encerro a minha fala, agradeço novamente, deixo aqui meu contato para quem tiver interesse e devolvo a palavra à professora Ângela. Muito obrigada.
Muito obrigada, professora Cinthia, por nos apresentar a sua pesquisa. que mostra que nós estamos ainda num momento de aguardo em relação ao que vai acontecer nessa área, né? Eu me pergunto, como eu já perguntei antes, se é possível realmente a gente sobreviver a essas tendências legislativas e se é possível a gente realmente apenas através da lei criar uma defesa em relação ao uso de dados, principalmente pessoais, por dois motivos: a questão técnica, né, que a lei simplesmente não consegue parar, e também porque, mesmo que a gente consiga proibir ou sequer tornar públicos os nossos dados pessoais, a mineração de dados atualmente tem uma capacidade impressionante de chegar a dados pessoais sem que sequer tenha acessado a eles, né? E aí nós entramos de novo na questão da inteligência artificial. So, I thank you a lot, and I thank you, the audience, also, and now we can have a good moment with questions, and we have some questions already from the audience. The first one is for Professor Thomas. Yeah, and the first question is from Valeria Bastos. He asked, this set of laws mix public and private rights regarding data founded by government support. How to reconcile this large set of laws in operational terms? So, Professor Thomas.
Yeah. The Data Act will, of course, lead to opt out contractually at the maximum, because what will happen after the Data Act, that we have hundreds of contracts with Volkswagen and its car users, car buyers, which these contracts allow Volkswagen to use all the data. So it leads to inflation of OILAs, we call it OILAs, or end user license agreement, and short contracts made by Volkswagen. So this short end user license agreement will result in hundreds of contracts. So in order to use a car. So I'm, as you can imagine, I'm totally against the Data Act. It's a masterpiece of bureaucratic regulation. Nobody knows what it's really for. And Ângela, I was really impressed by your introduction to my person. Remember me as to my sentence, information wants to be free. So we should really stick to the principle, especially in the area of non-personal data, that has been mentioned by my colleague Yogesh. We should not over-regulate. We should leave the area of non-personal data unregulated. So because we have a principle, information needs to be free, we have some correction measures, which Yogesh has mentioned, that is some competition law. But apart from competition law, we don't need lawyers at all. So I'm totally against an over-regulation in that area. You should.
Thank you, Professor Thomas. And I don't know if Professor Yogesh want to talk something about that also. Feel free, please.
So I generally tend to agree on what Professor Thomas has just mentioned. One of the questions that increasingly even get asked in India is the kind of compliance cost for companies which operate in multiple jurisdictions. And the compliance cost would, for example, in the context of PDP, personal data protection, I'm not talking about NPD. In the context of personal data protection, there was a data localization requirement in the bill that was proposed in 2019, which now has been withdrawn. Now, if there are, different kinds of what you call requirements in different jurisdiction, it becomes extremely difficult to navigate. And then what could happen, eventually, is that in certain jurisdictions where, it seems like there is over-regulation, companies may want to withdraw from those markets also. And in that sense, then, unless you have competing huge data companies to replace them, etc., then the consumers also lose out on the efficiency provided by the products that they launch in your particular jurisdictions. So I would stop it there, but then there is another question that has also been directed to me. There is a second question which we can take later after others speak. Thank you.
Okay. Yes, and we have also from Valeria Bastos to Professor Thomas, will the EU and US Trade and Technology Council not have the role of coordinating US and European Union relations regarding data transfer and ownership?
Of course, there's a need to harmonize even international rules in the area of US and Europe. But that's not for this body which the colleague mentioned, because this body is informal. It's an informal meeting of ministers thinking about innovation and technology in the 30th century and so on. So it's very informal. We don't have an area where we could harmonize technology rules clearer. And you see the problem in the GDPR, when the US and Europe created a new framework for cooperation with personal data, immediately Mr. Schrems, the famous Austrian guy who sued against every regulation in the area, stated he wants to sue against this agreement. So the case will be decided between US and Europe by the courts.
Okay, so we have now a third question for Professor Yogesh. Professor Yogesh, I think you saw it, yeah?
Yes,
let me see.
I've seen the question. The question is, yes, you want to read
please,
it? Sorry.
I can read it, yes, if you want.
No, it's not, I thought you wanted to read it. I can read it myself. I can see the question. Thank you. Could this complex regulation not lead firms to opt for contractual relationship in the provision of data-driven services instead of intellectual property rights? I think that's precisely what is actually happening. So what is happening is large quantities of data today is transacted largely through contractual frameworks, primarily because firms hold de facto exclusivity through principles of breach of confidence, etc. So wherever there is a possibility that this data can be exclusively held in the possession of the firms do use contractual models rather than any kind of intellectual property model. In fact, just to mention a point, the whole reason why the data producers' right proposal failed in the European Union is likely owing to the fact that big data companies do not want any positive kind of property rights protection. They're extremely happy with the current structure in which there are layers and layers of different kinds of laws that provides them the protection in the form of contract law, in the form of technology, anti-hacking regulations or laws, in the form of your breach of confidence laws, or to some extent, even in Europe, for example, there is also sui generis right for databases, right, for data. So naturally, I think a combination of this works for them, and they don't need any positive form of intellectual property rights, because all this are not rights in rem, they are rights in person, right? And if you introduce a property right, it's going to be a property right in rem as against the world. And I think the current structure itself is very optimal. You don't need to either or legislate from an IP perspective or regulate from a regulation perspective. I think a kind of current mix is working well, unless we have very large degree of evidence to show that there is a strong case for market failure. And we really need to make the difference between market failure and public interest. there could be a vital public interest. But if that public interest is not driven towards efficiency conditions, then it could really affect the current market structures, and that could lead to lesser incentives in the current data-driven industries. And I completely agree with this formulation of the question itself, that if it becomes more and more complex, then definitely less and less data is going to be put out by these companies in the public domain. And that's why, because there has been, for example, many scholars have argued that companies would want to go towards a commons-based model in terms of regulation of data. But unless it comes voluntarily from the companies and they form these private collectives, I don't think any form of government regulation to put the data together is going to help the cause of both creation of the data and then consumption of the data by large sections of the industry. Thank you.
Thank you, Professor Yogesh. We have also a question that was made in Portuguese to Professor Thomas Hoeren. I'm not sure. Let me see. Professor Cinthia, she wants to do a comment too. Professora Cinthia, por favor.
Thank you, Ângela. Just to remember, we have in all legislation, we have 3 pillars. Yeah, the data, the titulars of data, us in this case, yes, and the treatment, the processing, what to do with the data. So it's very important to coordinate actions, only not in law or juridical aspects, but technological aspects, because the operation or the coordination about all this legislation, property rights, fundamental rights, and all the other rights involved in this discussion, need to observe and take care about the technological aspects and technological acts too, because we have normalizations, standards, and a lot of things to do and to learn to support juridical and law aspects. Thank you.
Mm-hmm.
Thank you, Professor Cinthia. And this is a very sensible object. And it's very strange that we need to have faith in law, but this is very hard because it's hard to believe that it will work. Yeah, so I'm asking myself also how we can manage this without some maybe technical device that could block something, and maybe some regulation on some that could do this work, because we cannot just ask to this system works with only the law. Mm-hmm. I don't believe. So we have a small question for Professor Thomas Hoeren, and is from Terezinha Alves. She just wants to understand what, Professor Thomas, you mean when you spoke about commercial data right, because it was in emphasis in your slides.
That was a translation area problem which I have caused, translating my slides into Portuguese. I mix up the words law and right. I don't mean commercial data right, but commercial data law. What I want to say, we need a clear and transparent rule system for commercial data. It doesn't matter whether personal or non-personal. We need to have a common system, perhaps the international system of legal rules for selling data, for mistakes of data, for liability caused by data. That needs to be governed by this commercial data law, not right. Right is missing.
Okay, so to all, Professor, I don't know if you have some questions to each other. Please feel free to make them, or I will just ask to Professor Thomas and Professor Yogesh and Professor Cinthia about these rights of the data owner. The letter of the law is complex, and one can say maybe beautiful. I'm not sure about that, but it is really hard to know and to see it working. How are your expectations regarding this in the reality?
So when I'm starting, you cannot think anymore about a concept defining data ownership. There is no ownership in data. So that doesn't work. So we need, I think I like the presentation of my colleague Yogesh, who clearly stated that there was no rule needed for normal data, raw data. So the general principle should be these data can be used freely. So they are common heritage, so no need to regulate. But in harsh contexts like unfair competition law, we need some regulation for the misuse of these data.
Oh, yeah.
That's all. But we have these rules already. That's my opinion.
Yeah, I agree. Yeah, that's right. And Professor Yogesh and Professor Cinthia, how are your expectations?
My expectation with reference to, at least as far as non-personal data governance is concerned, I think was also emphasized a bit towards the end of my presentation lecture, wherein I think that there is going to be at least some form of optimization of regulation over a period of time. The reason is also that while data is currently being generated, raw data is being generated by big data industry, not many people within the industry and within downstream industries actually know the actual and potential value of that data themselves, because it's just happening that they are collecting raw data. As the industry progresses and as we enter into a deeper AI integration, I think the question of whether the current legal mechanism is working with reference to data licensing and whether the industry is optimally functioning will become a question that needs to be undertaken from a public policy perspective. And at that time, it's most likely that at least in jurisdictions like India, it is very likely that the Competition Commission may intervene, even if we don't proceed towards a full-fledged regulation based on the idea that there is going to be a market failure. At some point of time, I think in the years to come, there is going to be a lot of emphasis on the use of competition law, which is already happening in the European Union, for example, in India also, and in smaller jurisdictions like within the region. So that's what I think at this moment, but I don't know because I don't hold the crystal ball to look into the future. But it seems like competition law is going to play a role in data governance, particularly non-personal data governance.
Do you want to talk something, Professor Cinthia?
Yes. Sometimes I think that this situation is like Goliath and giant. We are the Goliath and the big techs are the giant. So Goliath win the fight. We have good laws and efficient laws and efficient and possible technical legislation or technical normatizations, some to help the public or private sectors to understand about this and to operate all this legislation. Otherwise, the giant will win.
Yeah, okay. Well, we are at the end of this panel, and I have a lot of questions for you, but I know that it's time and I cannot do these questions, and I hope we can meet again soon. I will be waiting for this moment. I just can say now, thank you very much. And we will say goodbye to our audience. And really, really thank you, Professor Thomas, Professor Cinthia, Professor Yogesh. I really hope to see you again soon. Okay? Bye-bye.
Bye-bye.
Bye-bye. Thank you.
Thank you very much. I think they already closed the windows. And I really hope we...
Thank you.